10 seconds. 5 seconds. Start reverting back to the factual situation of the case at hand. Admittedly, the appellant is in possession of the buildings in question since 1958. They have been permitted to raise huge constructions, and the nature of construction is of wide range. An administration block along with tanks for storing petroleum and had been constructed. A boundary wall around installations and administrative block had also been constructed. Admittedly, the appellant is in exclusive possession over the lands in question along with construction thereon without any let or hindrance from the administration. Further, the appellant had been continuously carrying on their business. Possession has been granted. There is a strong presumption in favor of tendency. Stanza. That being the case, it is for the appellant to show that despite the right to possess the demised premises exclusive, a right or interest in the property has not been created. The burden therefore would be on the appellant. The aforesaid burden is not discharged in the present case, rather for the purposes resisting its eviction from the suit land in the proceeding initiated under the Public Premises Unauthorized Occupants Eviction Act. The appellant has taken the stand pleading non-applicability of the Indian Easement Act and has themselves termed the arrangement as a tendency. The said factor is also a vital factor, as on the own showing of the appellant the arrangement was nothing but a lease. The appellant therefore cannot take up a plea by which they appropriate and reprobate at the same time. We may also notice the undisputed fact that in the present case the parties have agreed that for the purpose of determination of the agreement 3 calendar months notice had to be given. Undoubtedly, such clauses in the document in question has a significant role to play in the matter of construction of document. Clearly, if the parties to the agreement intended that by reason of such agreement merely a license would be created, such a term could not have been increased. Inserted stanza. It is a well settled legal position that a license can be revoked at any time at the pleasure of the licensee. Even otherwise, unless the parties to the agreement had an intention to enter into a deed of lease, the administration would not have agreed to demise the premises on payment of rent in lieu of grant of exclusive possession of the demise land and further stipulated service or 3 months notice calling upon either party to terminate the agreement. In view of the same, the argument advanced by the learned counsel of the appellant that a stipulation having been made in the agreement itself that by reasons thereof the appellant shall not be a tenant and thus the deed must be construed to be a license cannot be accepted. In our considered wide, such a clause may at best be one of the factors for construction of the document in question, but the same by itself certainly be a decisive factor. Stanza. By reason of the agreement in question, the building in question do not belong to the administration. Admittedly, it belongs to the guarantee, that is, appellant herein. As discussed herein before, the oil tanks has been construed as buildings for the purposes of tax. Therefore, Section 119 of the MCD Act would not apply to the building in question. That being the case, the guarantee appellant is liable to pay tax although the ownership of the land may belong to the administration. Section 115 of the MACD Act clearly provides that the general tax shall be payable in respect of lands and buildings. Such lands and buildings may be in lawful occupation of the owner. The occupation of the said building may be lawful or unlawful. Even in a case where owner apartments are constructed on the land belonging to the government or a statutory body, but the occupier of the apartment is liable to pay tax. Stop.